Thank you all for joining us for our webinar today regarding the Consumer Financial Protection Bureau's Remittance Transfer Rule. My name is Eric Goldberg. I am a counsel in the Bureau's Office of Regulations. First, I want to thank you for tuning into this webcast. We know that there is a lot of interest in the Remittance Transfer Rule, and we hope that this overview will be helpful as you figure out whether or not you have compliance obligations under the rule, and as you are working to implement the rule's requirements. Please note that this webinar is revised from the webinar first issued in the fall of 2012 and is current as of July 2013. Many of you are at different stages of implementing the remittance rule. So, to level set, today I am going to provide an overview of the rule that will tackle some of the basics. But at the same time, I will be getting into the weeds on some of the trickier parts, and I will also discuss recent changes made in the spring of 2013 to the rule and questions that have been raised as a result of those changes. This webinar replaces the previous webinar released by the Bureau, and the previous webinar should no longer be considered as accurate in light of the recent changes to the rule. To that end, a number of individuals have raised questions or raised issues regarding implementation of the rule, and we thank you for those questions. Rather than saving the questions until the end, we thought it might make more sense to address them in the course of the overview as we are discussing various topics. Of course, I needed to give the disclaimer that this is staff guidance and not any official interpretation of the Bureau or legal advice. To the extent that the text of the slides or anything I say conflicts with the text of the rule should be controlling. Official interpretations are incorporated in the staff commentary to the rule and are not presented herein. With that, let's address why you are listening today. In 2010, the Dodd-Frank Act expanded the scope of the Electronic Fund Transfer Act's requirements to impose requirements regarding certain international fund transfers. These transactions are referred to in the statute as remittance transfers. To implement the new Dodd-Frank Act requirements, the Bureau issued a new rule that generally requires companies that provide remittance transfers to give their customers certain disclosures. The rule also establishes cancellation and error resolution procedures. The transactions covered by the rule are called remittance transfers or remittances. Your customers may also refer to them by other names, such as international money transfers, international wires, or international bill payments. The CFPB's rule has been issued in multiple parts. I'm putting up on this slide the citations for the relevant Federal Register notices and a link to our website where you can find them and other important materials. To make things easier, we have also added an unofficial PDF of the complete rule and official interpretation to the rule on our website. The website also includes a link to a small business compliance guide that provides additional answers to questions related to the rule. A revised guide, version 2.0, was recently published on our website. Our website, as I will discuss towards the end of this presentation, also includes an email link where you can subscribe to updates regarding the rule, as well as other compliance materials. For those who are newer to the rule, this slide contains the key questions that you should be thinking about. In today's presentations, I am going to go over all of these in detail. The first three questions relate to whether or not providers are subject to the rule in the first place. First, do you offer consumers a way to send money abroad? Second, if so, are the transfers you provide remittance transfers under the rule? And finally, are you a remittance transfer provider? I'll be talking about each of these factors today, but generally speaking, if the answers to any of these questions is no, then you will not have compliance obligations under this rule. If the answer to all of these questions is yes, you will need to comply with the rule. If that is the case, the next three questions are the key legal questions you will need to consider. What are your disclosure obligations? What cancellation rights do senders have? And what are your error resolution obligations? We are going to discuss all of these today. This slide addresses the first two key questions. Do you offer consumers a way to send money abroad? And are these transfers you send remittance transfers under the rule? To start off, a remittance transfer is defined by the statute, and the rule adopted by the Bureau closely tracks the language of the statute. A remittance transfer is an electronic transfer of funds requested by a sender to send to a designated recipient, and that is sent by a remittance transfer provider. You need to have all of these elements in order for there to be a remittance transfer. That said, this is a very broad definition. It generally applies whether or not the sender holds an account and whether or not the transfer is an electronic fund transfer. So it covers more than traditional worker remittances. The rule covers many types of international transfers, such as cash-to-cash money transfers, international wire transfers, international ACH transactions, and certain prepaid card transfers. I'll get into this in more detail shortly, but let me get back to the definitions. As I said, the definition of remittance transfer covers an electronic transfer of funds. Focusing on what the word electronic means, where a provider issues a check, draft, or other paper instrument to be mailed abroad, this is generally not electronic and thus not covered by the rule. With respect to online bill payments, generally online bill payments are sent electronically. However, sometimes the bill pay service will instead disperse a check from the consumer's account. Comment to the definition of remittance transfer provides, among other things, that this is not an electronic transfer of funds if the provider explicitly states that such a payment will be made solely by check, and in particular, a check drawn on a consumer's account. We have received questions about checks drawn instead from omnibus accounts. In some instances, a bank's process for sending bill payments results in the check technically being drawn on an omnibus account at a bank, rather than directly from the consumer's account, although the funds will be debited from the consumer's account. We do not believe that this technical difference should result in a different application of the exception to the rule. So, if a paper check is sent abroad by a bill payment service, and such a check is drawn on an omnibus account, the payment should be excluded from our rule. So in addition to needing to have an electronic transfer of funds, in order to have a remittance transfer, you also have to have a sender and a designated recipient. The rule also closely tracks the statute here in terms of definition. For sender, the rule states that a sender is a consumer in a state who primarily for personal, family, or household purposes requests a remittance transfer provider to send a remittance transfer to a designated recipient. On the other hand, a designated recipient is any person specified by a sender to receive a remittance transfer at a location in a foreign country. A designated recipient can be either a natural person or business entity. We received a question about why transfers to businesses are covered by the rule. This comes from the statute, which defines a designated recipient as, quote, any person. So payments sent abroad for tuition or utilities could be covered by the rule. Commentary provides guidance as to when there is a sender and a designated recipient for purposes of the rule. In particular, we want to note that for account-based transfers, you would look to the location of the account, not the physical location of the consumer requesting the transfer or to the recipient. Thus, if someone has a U.S. bank account and he gives an ATM card to his daughter studying abroad who can access the U.S.-based account, we would not consider withdrawals from this account at a foreign ATM to fall within the scope of the rule. On the other hand, if the daughter opened an account abroad and the parents wire funds from an account in the United States to that new account abroad, that may be a remittance transfer even if the daughter is now back home in the United States. The commentary also clarifies that the sender and the recipient may be the same person. For example, the sender may send funds from his or her bank account in the United States to a separately owned bank account abroad. We have received questions about how this applies to members of the military who are stationed on bases abroad. This is a highly fact-specific question, but the answer depends on whether the service member or the service member's account is in a U.S. state, territory, or possession. Again, you look to where the sender and where the designated recipient are located under the rule and make the determination based on those locations. Now, continuing to talk about what transactions are covered by the remittance rule, the Bureau has also received a number of questions about the applicability of the rule to transfers from business accounts. Generally speaking, the rule covers consumer-to-consumer transfers and consumer-to-business transfers. However, because there needs to be a sender, that is, a consumer, the rule does not cover business-to-consumer or business-to-business transfers. Staff also believes that the rule does not apply to transfers from sole proprietor accounts. The Bureau has also received questions about transfers from trusts, IRAs, and ERISA accounts. The remittance rule is not intended to cover transfers from an account held by a financial institution under a bona fide trust agreement, including those that qualify as a trust under the Internal Revenue Code. Where trusts are not involved, transfers initiated by someone acting with a power of attorney or who has guardianship rights may be subject to the rule. The definition covers a number of different transfer methods, but generally there are two common types of examples. Those that are called closed network transfers, such as cash-to-cash transfers sent through a money transmitter. In a closed network, participants are linked by contract and the central player has a high level of end-to-end control. There are also open network transfers, such as international wire transfers and international ACH transactions. With these transfers, there is typically a chain of relationships in which no party generally has end-to-end control. There are also newer hybrid models, but these are some general categories. Inclusion of consumer-initiated open network transfers in the rule raised a lot of comments and questions, but this is driven by the statute, which expressly contemplates them. Finally, as I mentioned earlier, the definition of remittance transfer requires that a transfer be sent by a remittance transfer provider. I will get more into who is a remittance transfer provider shortly, But just to note that the commentary explains that this means that there must be an intermediary that is directly engaged with the sender to send an electronic transfer of funds on behalf of that sender to a designated recipient. The comment provides several examples of transactions that are not remittance transfers. Among them, I want to mention a few. First, a consumer providing a debit, credit, or prepaid card directly to a foreign merchant as payment for goods or services would not be a remittance transfer. For example, calling a store in Mexico to order something to be sent to you in the United States, and you give that store your credit card number, would not be a remittance transfer. Second, consumers providing checking account numbers directly to foreign merchants would not be considered remittance transfers. In addition, where a merchant sends ACH payments requests to the consumer's bank would also not be a remittance transfer. For example, if you contact a utility abroad directly and have that utility debit your account in the United States, such a transfer would not be a remittance transfer under the rule. In these examples, there is not an intermediary that is directly engaged with the consumer to send an electronic transfer of funds. The rule also does not require a financial institution to provide disclosures when a sender provides his account number to a third-party payment service, and that payment service debits the sender's account. Again, the institution is not acting as an intermediary here. However, in some situations, the third-party payment service may be a remittance transfer provider under the rule. The rule also has two exemptions from the remittance transfer definition. First, small value transactions. Transfers amounts of $15 or less are excluded from the rule. In contrast, there is not a cap on the dollar amount that could be a remittance transfer. Second, securities and commodities transfers. The rule exempts transfers in connection with the purchase or sale of securities that are excluded from the definition of electronic fund transfer under 12 CFR 1005.3C4. The commentary in Regulation E to this provision provides examples of how this exception works. So this slide provides some examples of transfers that are and are not remittance transfers, assuming no exemption applies. So now we have answered the first two key questions. Do you send money abroad, and is there a remittance transfer? The next key question is, who is a remittance transfer provider? As defined by statute in the rule, a remittance transfer provider means any person that provides remittance transfers in the normal course of business. Normal course of business depends on the facts and circumstances, including the total number and frequency of transfers. In August 2012, the CFPB adopted a safe harbor regarding normal course of business. A large number of our questions have come in about this safe harbor, so let's spend some time talking about it. Under the safe harbor, if a provider provided 100 or fewer remittance transfers in the prior calendar year, and 100 or fewer remittance transfers in the current calendar year, it is not providing remittance transfers in the normal course of business and will not be a remittance transfer provider under the rule. The 100 transfer threshold includes all types of remittance transfers that would be remittance transfers under the rule. If a provider sends 50 international wires and 75 international ACH transfers, the provider would count those all together and would be providing more than 100 transfers in a year. For counting to 100 transfers, you do not include transfers not covered by the rule, such as business account transfers or domestic transfers. Only include transfers that would otherwise be covered under the remittance rule. The remittance rule does provide a transition period if the provider exceeds the 100 remittance transfer threshold. The rule provides a reasonable period of time not to exceed 6 months for compliance. Alternatively, you could still show under the facts and circumstances that a provider is not a remittance transfer provider. Some have questioned the 100 transfer safe harbor threshold. The proposal we issued in early 2012 solicited comment on a threshold of 25 transfers per year. The final rule settled on 100 transfers. As the Bureau stated in issuing this safe harbor, it believes that 100 transfers per year serves as a reasonable basis to identify persons who occasionally provide remittance transfers, but not in the normal course of their business. This equates to about 2 transfers per week. The Bureau expects that a meaningful number of institutions will be exempt from the remittance rule by operation of the safe harbor. That said, the Bureau expects that most consumers who send remittance transfers will continue to receive the rule's protections. The Bureau does intend to monitor the impact of the safe harbor threshold, and we welcome additional data in this regard. Let me take a moment to address 3 additional questions that we have received about the operation of this safe harbor. First, we have been asked whether, if a business is not a remittance transfer provider under the safe harbor, consumers have the same rights under the rule? The answer is, if a provider is not covered by the rule, the provider does not have any additional error resolution obligations beyond what the provider must already provide. For example, if a provider sends international ACH transactions internationally, consumers will generally have pre-existing Regulation E rights, including error resolution rights. But the remittance rule's error resolution provisions and other provisions of the remittance rule will not apply. Second, a number of institutions have asked whether a transaction could be a remittance transfer if an institution does not send a wire directly to a bank abroad, but rather sends the wire instructions through another larger financial institution in the United States. Other institutions have asked whether it matters that the correspondent institution provides more than 100 remittance transfers a year. If you use a correspondent institution to send a wire transfer abroad, yes, that transaction could be covered. What matters is that you have a sender requesting you, the sending institution, to send a remittance transfer to a designated recipient abroad. So you may be acting as a remittance transfer provider, even if you're using correspondent institutions to get the funds to the recipient. However, in terms of counting towards the 100 transfer threshold, you should focus on the number that you yourself as an institution are providing. For example, if you send only 25 international transfers, but you use an unrelated correspondent bank that sends 500 transfers, you would only count the number of transfers that were sent by your institution. If your institution consistently provides 100 or fewer transfers per year, you will not be providing remittance transfers in the normal course of business, even if you are sending wires through a correspondent institution that it itself sends more than 100 transfers a year. Just note that if you operate through various agents, you should count transactions at each agent location collectively. Finally, an institution has asked whether they can cut off international wire transfers at a number below 100 transfers each year. The remittance rule does not directly address this. It does not prohibit institutions from implementing cutoffs. So let's take an example. Consider an institution that has 65 transfers in 2012, 73 transfers in 2013, and 124 transfers in 2014. The institution would not have to comply with the remittance rule at all when it takes effect in 2013, because it was under 100 transfers in 2012 and stayed under 100 throughout 2013. However, the institution would only be exempt in 2014 until it made the 101st transfer. As of that date, the institution would have up to 6 months to come into compliance unless it could show under the facts and circumstances that it was not providing remittance transfers in the normal course of business. Assuming that's not the case, transfers occurring until November 1, 2014 would be exempt. However, any transfers after November 1, 2014 would be covered by the rule. If the 101st transfer is not made until November 1, 2014, the 6-month transition period would extend to May 1, 2015. This is a more practical compliance slide rather than legal guidance on the rule, but in thinking about whether or not you fall within the rule's safe harbor, you should be thinking about the various places where remittance transfers might be sent across your business. For example, large institutions may have various retail, high net worth, or commercial divisions that send wires either from US dollar to US dollar or that involve a foreign exchange. You may also use international ACH or have certain closed network methods of sending funds abroad. The way in which you issue or send prepaid cards or payroll cards may also be covered by the rule. In addition, brokerage institutions or brokerage divisions of a larger institution may also send wires or other transfers that are covered by the rule. So once you have determined that you are a remittance transfer provider sending remittance transfers, you will then need to think about your compliance obligations under the rule. The rule establishes a number of obligations for providers. Those include disclosure obligations, which include providing both a prepayment disclosure and a receipt, and implementing certain foreign language disclosure requirements, cancellation and refund procedures, and error resolution procedure obligations. I'll discuss each of these requirements in the next several slides, along with clarifying points. I will mention agent liability and special rules for transfers scheduled before the date of transfer, separately at the end. The rule generally requires 2 disclosures for each transfer, a prepayment disclosure and a receipt. I will explain later an alternative disclosure method. I'm going to spend a bit of time on this slide. I'm first going to talk a bit about the elements that are on the disclosures, and then we'll talk about timing and format of the disclosures. The first disclosure is called a prepayment disclosure, which, as its name suggests, is required prior to payment and which, among other things, includes a number of disclosures, including the amount to be transferred. front-end fees and taxes, the foreign exchange rate, covered third-party fees, and the total amount to be received. Let me go back and walk through each of these disclosures. The amount to be transferred is the amount of funds being sent to the designated recipient. This gets disclosed both in the currency in which the transfer is funded and the currency in which the transfer is to be received. Front-end fees and taxes are fees and taxes charged by the provider or passed on by the provider and charged to the sender, such as a tax charged by the state in which your institution is located. Front-end fees and taxes, together with the amount to be transferred, create a total amount paid that reflects the amount the sender is paying out of pocket to fund the remittance transfer. Providers must also disclose the exchange rate, if applicable. If it is a US dollar to US dollar transfer, in other words, if you are sending 100 US dollars to be sent in dollars to a recipient abroad, you do not need to disclose an exchange rate, but the transfer can still be a remittance transfer. In certain cases, disclosures may be estimated. I will talk more about estimates in a bit. However, generally speaking, disclosures must be exact. So, for the exchange rate, this means that providers cannot disclose that an exchange rate is unknown, floating, or to be determined. You need to provide actual numbers that apply to the transfer. The commentary to the rule states that if a provider does not have specific knowledge regarding the currency in which funds will be received, the provider may rely on a sender's representation for purposes of determining whether foreign exchange is applied to the transfer. If the sender does not know the currency in which funds will be received, the provider can assume that the currency in which funds will be received is the currency in which the remittance transfer is funded. So, in other words, if your customer requests that a remittance transfer be deposited into an account in US dollars, you do not need to disclose a foreign exchange rate, even if the recipient's account is actually denominated in Mexican pesos, and the funds are converted prior to deposit into that account. Covered third-party fees is a change from the original final rule that was changed by the Bureau in May 2013. The May 2013 rule makes certain distinctions with respect to the disclosure of other fees. Under the May 2013 final rule, providers need to disclose what is defined in the rule as covered third-party fees. I'll explain this a bit more in a moment. Generally speaking, though, the rule no longer requires as part of the disclosure fees charged by certain recipient institutions for receiving a transfer into an account. Instead, covered third-party fees are all other fees, including all fees for transfers not sent to an account. Total amount to be received. This amount reflects the amount transferred, minus covered third-party fees. However, this does not include any non-covered third-party fees as defined by the 2013 final rule, which I'll describe in a bit, or foreign taxes that may be imposed on the remittance transfer. In other words, the recipient might receive less than this disclosed amount. So, for example, if the sender pays $100 and correspondent institutions impose lifting fees totaling $5, you must deduct those fees from the $100 in the amount disclosed in order to calculate the total amount to be received. However, you would not deduct a $10 incoming wire fee if that fee was a non-covered third-party fee, nor must you disclose a $5 tax imposed by the beneficiary country. Instead of including those amounts in the total amount to be received, a disclaimer may be required. A disclaimer is required where non-covered third-party fees or foreign taxes may apply to a remittance transfer. The rule requires that providers include a disclaimer on the prepayment disclosure indicating that non-covered third-party fees or foreign taxes may apply to a transfer, and then reduce the total amount to be received. As part of this disclaimer, however, a provider could choose to provide the amount or an estimate of the recipient institution fees or foreign taxes that might apply to the transaction in order to provide this information to their customers. Examples showing how the disclaimer should look are available in the model forms provided on our website, and which I'll describe a bit more below. Let me explain a bit more the distinction between covered third-party fees and non-covered third-party fees. As I mentioned, the recent changes in 2013 to the final rule make certain distinctions regarding which third-party fees remain subject to disclosure. Generally speaking, the remittance rule no longer requires, as part of the disclosures, fees charged by a designated recipient's institution for receiving a transfer into an account, which is defined in the rule as a non-covered third-party fee. Under the final rule, non-covered third-party fees and foreign taxes may be disclosed as part of the new disclaimer regarding such fees and taxes. However, it is important to emphasize that if an institution or party is an agent of the provider, any fees that institution charges for receipt of a transfer into an account must be disclosed as a covered third-party fee. Several individuals have asked what must be disclosed and where a recipient bank who is not an agent of the provider imposes both a lifting fee on the remittance transfer as well as charges the designated recipient a separate fee for receipt of a transfer into an account. In such cases, although the provider would not have to disclose the fee imposed by the recipient institution for receipt of such transfer into an account because it would be a non-covered third-party fee, the provider would still be required to disclose the lifting fee charged by the recipient bank, as it is a covered third-party fee under the final rule. I should also note that account under the definition of a non-covered third-party fee refers to an asset account established for any purpose and held by a bank, savings association, credit union, or equivalent institution. Under this rule, however, a designated recipient's account would not include a credit card, prepaid card, or a virtual account held by an internet-based or mobile telephone company. Now that we've addressed the elements in the prepayment disclosure, let me turn to the receipt. The receipt includes all of the information required in the prepayment disclosure, as well as a few additional items. Provider must disclose the date of availability. Here, an exact date is required. A range of dates or an estimated date is not permitted. Particularly in the case of wires and ACH transfers, the exact date of availability may not be known, so the rule does allow a provider to disclose an outer limit and provide a statement that the funds may be available sooner. There is no limit on how far out the disclosed date may be, but we anticipate that competition will keep providers from dramatically overshooting the date of availability. We have received questions about disclosing the date of availability, including loads onto prepaid cards or the mailing of a prepaid card, or where transfers may be received in a country that spans multiple time zones. Under any of these scenarios, the provider is still required to disclose the date of availability. Furthermore, even though the examples in the comment relate to international wires, the rule always permits providers to disclose the latest possible date and then state that funds may be available sooner. Thus, for example, if you think a wire that is sent on November 1st is going to be available on November 3rd, but you also know that it might arrive later, you can state that the date of availability is November 6th, but that the transfer may be available sooner. Going back to the receipt, a provider is also required to disclose the name of the designated recipient, even if the designated recipient is also the sender of the remittance transfer. The provider must also provide on the receipt a statement about the sender's error resolution and cancellation rights. The rule contains model language for which you can use to develop this statement. The rule permits a short form on the receipt and a long form that must be given upon the sender's request. Finally, the receipt needs to disclose the provider's contact information, a state agency if required, and the Bureau's contact information. If the institution is a federally regulated bank, there is no requirement to disclose a state agency, just state-chartered institutions. All providers must disclose the CFPB's contact information, however. Now that I've gone over what has to be in the disclosures, I'm going to talk about the timing of all this. First, the prepayment disclosure must be given when the sender requests the transfer, but prior to payment for the transfer. Just asking, "What are your rates today?" is not a request by a sender. A consumer has to request an actual transfer to be made to an actual designated recipient. A prepayment disclosure is not guaranteed. If a customer walks out the door after giving a prepayment disclosure and comes back 3 hours later wanting to send that transfer, but in the meantime the exchange rates have changed, the provider is not required to honor that prepayment disclosure. Instead, what there is a requirement to do is to provide a new prepayment disclosure with updated information before payment is made for the transfer. Once the sender has indicated that he or she would like to move forward with the transfer, generally the receipt must be given when payment is made. So what does this mean? Most of the time when we talk about payment, we are talking about when funds are actually deducted from an account. But in this context, that doesn't always make sense, where there is sometimes a lag between authorization and funds being deducted from an account. So the commentary to the rule clarifies that for purposes of the rule, payment is made, for example, when a sender provides cash to the remittance transfer provider or when payment is authorized by the sender. So, if a sender requests that a financial institution send a wire abroad, the receipt would be provided when the payment is authorized, not when the wire is actually processed and sent out. There are special provisions in the rule for transactions conducted entirely by telephone and orally, and for mobile application text message transactions. If the transaction is conducted orally and entirely by telephone, the receipt must be mailed or delivered to the sender within 1 business day. However, if the telephone transaction is done from an account with the provider, as might be the case for a transfer from a consumer's bank account, the receipt can be given on the next regularly scheduled periodic statement or within 30 days after payment. I'll refer to this timing later on as the telephone rule. Now that I've talked about timing, I'm going to turn to disclosure format. Generally, under the remittance transfer rule, disclosures need to be clear and conspicuous, in writing, and in retainable form. This means the consumer must get a copy he or she can keep. Under the remittance rule, there is an exception to the requirement that disclosures be given in writing. If a sender electronically makes a request to send a transfer, the provider can give the prepayment disclosure electronically. We have received several questions about how the e-Sign Act works in conjunction with the remittance rule. The e-Sign Act is a long-standing federal law not specifically related to the remittances statute. It talks about how electronic disclosures can be made. Generally, when a disclosure must be provided in writing, the e-Sign Act permits electronic delivery of that disclosure if the consumer consents and other requirements of the e-Sign Act are also met. So, generally speaking under the remittance rule, if a sender electronically makes a request to send a transfer, the provider can give the prepayment disclosure electronically without e-Sign consent. However, to provide the receipt electronically, the provider must get e-Sign consent from the sender. In addition, nothing in the remittance rule limits the ability of a provider to provide electronic disclosures if the e-Sign Act is followed, including getting e-Sign consent. So, as I mentioned, generally the remittance rule requires that a sender be given a prepayment disclosure and a receipt. For some transfers, the request and payment may occur very close in time, so the rule does allow for a single alternative combined disclosure to be given in lieu of the prepayment disclosure and receipt. The way this works is that the combined disclosure must contain all of the information required by the receipt, but must be given prior to payment for the remittance transfer. And then, once payment is made, a proof of payment is required. We have been asked about the various ways proof of payment can be provided. The rule states that the proof of payment needs to be clear and conspicuous, provided in writing or electronically, and provided in a retainable form. Otherwise, the rule does not specify what the proof of payment must look like. However, the proof of payment enables a sender to demonstrate that the combined disclosure received was part of a completed remittance transfer, and therefore the sender can assert cancellation and error resolution rights. The proof of payment also helps providers determine which transfers have actually been completed, so that a transfer cannot assert these rights without having actually paid for the transfer. So what the proof of payment looks like depends on how a provider wants to manage this issue. As with the receipt, proof of payment is given when the transfer is authorized, not when the actual payment is processed. Note again that for purposes of the remittance rule, payment is made when a transfer is authorized. We have been asked whether it would be okay for an agent to keep the proof of payment. While agents can certainly keep a copy, the sender also needs to be provided proof of payment in a retainable form. There is a slightly different disclosure regime for remittance transfers scheduled before the date of transfer. In lieu of a proof of payment, the provider must provide a confirmation of scheduling. We'll talk about this separately at the end of the presentation. There are also foreign language disclosure requirements which may apply to remittance transfers. I will go through how these requirements apply and then give an example. Disclosures must be given in English, and either each foreign language principally used to advertise, solicit, or market remittance transfer services at a particular office, or in the language primarily used by the sender with the provider to conduct a remittance transfer, assuming it's one of the triggered languages. Note this is at an office, so newspaper ads do not trigger the foreign language requirement. For example, assume that Spanish, Vietnamese, and English are principally used to advertise remittance transfers at a provider's office. Giving disclosures in Spanish, Vietnamese, and English, or just Spanish and English if Spanish is primarily used by the sender to conduct the remittance transfer, would comply with the rule's foreign language disclosure requirement. Note again that special rules apply for telephone transactions. Providers must give prepayment disclosures orally in the language primarily used by the sender with the provider, even if the transfer was not advertised in that language. The receipt again follows the normal telephone rule. When disclosures are provided orally, they do not need to be provided both in English and in the foreign language. The rule also imposes specific formatting requirements for disclosures. These requirements include proximity, grouping, font size, and segregation requirements. To aid providers' compliance with the rule, we have provided a number of model forms which providers may use. Some of these forms are designed to look more like register receipts, and others like a printout 8.5 by 11 piece of paper. Note that in updating the rule in 2013, the Bureau issued new model forms in light of the changes that were made. These forms have eliminated the requirement to disclose foreign taxes because of this change and the changes regarding the disclosure of certain third-party fees. Many of the model forms now include a disclaimer indicating that the recipient may receive less due to fees charged by a recipient's bank and/or foreign taxes. The model forms also show examples of how providers may, at their option, disclose non-covered third-party fees or foreign taxes that may apply to the transaction as part of the disclaimer. Use of the appropriate disclaimer is required where a provider knows or does not know whether non-covered third-party fees or foreign taxes may apply to the transfer. These model forms are all available for download at our website at the link I provided at the beginning of the presentation. As I said earlier, items disclosed by providers must generally be exact. However, the rule implements several statutory exemptions that permit a provider to disclose estimates. There are also several other methods in which you can disclose an estimate. The first exception is what is known as the temporary exception. This applies to insured depository institutions and credit unions. The statute provides that this temporary exception expires July 21, 2015, although the Bureau has the ability to extend the exception for an additional 5 years if the Bureau determines that expiration would negatively affect the ability of providers to provide remittance transfer. Congress limited the exception to insured institutions. Accordingly, the exception does not include providers that are not insured institutions, such as most money transmitters and broker-dealers, even if they send remittance transfers through open networks. In addition, the exception applies to the provider only. If the provider obtains information from a business partner and the business partner qualifies for the exception, this does not mean that the provider also qualifies for the exception. For example, a correspondent institution may provide estimates to its retail customers, but that does not entitle the institution to automatically provide estimates to its customers, even if it is obtaining information from the correspondent, but it itself is not an insured institution. So going back to how the exception works. The temporary exception applies where the insured institution cannot determine amounts required to be disclosed for reasons beyond its control. For example, maybe the current business model used by that institution does not permit it to know the exchange rate used for the remittance transfer. It is worth noting that for purposes of the temporary exception, a relationship with a direct correspondent institution is considered to be within the provider's control. So if the first correspondent in a chain is setting an exchange rate, the financial institution cannot take advantage of this exception. The second exception is a permanent exception that applies in 3 ways. It applies to any provider that cannot determine exact amounts because of the laws of the recipient country or the method by which transactions are made in the recipient country. The methods exception is a limited exception that applies to international ACH transfers, where the terms are negotiated between the United States government and the recipient's country government, where the rate is set after the fact by the country's central bank or other governmental authority. We understand that this applies to the Directo a Mexico program. A separate permanent exception applies for transfers scheduled 5 or more business days in advance. In the rulemaking the Bureau issued in August 2012, we provided specific disclosures for those transfers. Finally, in the changes made by the Bureau in 2013, the Bureau created a separate permanent exception to the optional disclosure of non-covered third-party fees and foreign taxes as part of the disclaimer regarding such fees and taxes. In order to encourage the optional disclosure of such information, the Bureau now allows providers to estimate such fees and taxes based on reasonable sources of information. The Bureau has published a safe harbor country list providers can rely on for purposes of the permanent exception. Unless the provider has information that a country's laws or the method by which transactions are conducted in that country permit a determination of the exact disclosure amount. The countries list is available on our website at the link provided. Currently on the countries list as of July 2013 are the following countries and other areas: Aruba, Brazil, China, Ethiopia, and Libya. In addition to the Bureau's list, the rule allows estimation based on a provider's own knowledge that it cannot determine the exact amounts when the disclosure is required because A, the laws of the recipient country do not permit such a determination, or B, the method by which transactions are made in the recipient country does not permit such a determination. This means a provider may independently determine that an exact disclosure is not possible. With respect to the 5 countries or other areas on the list, we've been asked how we came up with this list. The Bureau gathered intelligence from sources in the industry, consumer groups, and other stakeholders and possible candidates for the list. We attempted to verify the legal authorities in those countries and other areas. In particular, we inquired, often through diplomatic channels, with the relevant regulatory and banking authorities in the candidate countries and areas to determine whether their laws do in fact prevent disclosure of exact amounts. We also consulted with other legal authorities with regard to foreign laws and regulations to verify our research. In some instances, countries were suggested as having laws that prevent disclosure of exact amounts, but further research indicated that the laws were not in fact an impediment. We welcome suggestions with respect to new countries to consider for the list, and have contact information related to how to provide this information on our website. Additions we make to this list will be effective upon release. If we believe that it may be appropriate to remove a country from the list, we have stated we will provide 90 days advance notice that the Bureau is considering changing its interpretation. If the Bureau determines that it is appropriate to add an additional country or countries to the list, we will release a revised list adding those countries as soon as reasonably practicable. We welcome suggestions along with supporting legal authority translated into English. Now that we've outlined the exceptions to which estimates may apply, let's talk about how you can actually provide estimates. There are essentially 2 methods for estimating under the rule, except for those transfers where estimates are based on reasonable sources of information, as we've already discussed the way to disclose these estimates. The first method is to use the specific bases listed in the rule for estimating: the exchange rate, transfer amount, other fees, and the amount received. And the other is a safe harbor. This permits the use of non-listed methods as long as the recipient receives the same or greater amount of funds than what was disclosed in the estimate. With respect to the listed methods, I'll go through a few examples. To estimate the exchange rate, the rule permits the provider several options for estimating. For example, the provider can calculate an estimate by looking to a publicly available rate and adding a margin typically applied for transfers to that country. To estimate covered third-party fees deducted from the amount received, an estimate must be based on either the provider's most recent transfer to the recipient's institution or a representative transmittal route identified by the provider. The commentary to the rule clarifies that the representative transmittal route is a route that leads to the designated recipient's institution, not representative beneficiary institutions. For example, imagine U.S. Bank A transfers to foreign bank X, not U.S. Bank A transfers to foreign bank X, Y, or Z. The rule does not permit ranges to be provided. All disclosures must be specific numbers. And again, there is a specific regime with respect to transfers scheduled 5 or more business days in advance. In addition to the disclosure obligations described previously, providers also have cancellation and refund obligations. Under the remittance rule, the sender generally has a right to cancel the transfer within 30 minutes of payment, unless the transferred funds have been picked up by the designated recipient or deposited into an account held by the recipient. There's been some confusion about this, so let me spend a moment on the topic. The 30 minutes is tied to the provision of the receipt to the sender. So, you would not provide a prepayment disclosure, then wait 30 minutes, then provide a receipt. Let's walk through an example. Let's say a consumer enters your institution and asks to transfer $1,000 from her account to an account in Paris. The consumer asks for the transfer to be received in euro. The U.S. institution provides the prepayment disclosure. If the consumer reviews the prepayment disclosure, decides to authorize the transfer, the institution would immediately give her the receipt that has the same disclosed figures that were on the prepayment disclosure. Once the consumer receives the receipt, she then has 30 minutes to cancel the transaction, regardless of whether the transaction is actually initiated or processed by your institution. We expect that due to the nature of certain types of transfers, in some cases providers will provide the receipt, wait 30 minutes, then send the transfer. For example, a bank may decide to wait the 30 minutes before initiating a wire transfer. Please note that there's no requirement that a consumer remain in the institution until the 30 minutes expires. Again, I want to emphasize that the rate that is provided on the prepayment disclosure and on the receipt is what the consumer must be provided. So, if you decide to wait 30 minutes before processing a remittance transfer, and rates fluctuate after that 30 minutes is over, the institution still must honor what was disclosed to the consumer. Hopefully this clarifies how cancellation works under the remittance rule. I also want to note that the sender's request to cancel a transfer can be oral or written. It also may be given at an agent and be effective when given to that agent. That said, there is no requirement for agents to resolve refund requests, or, as we will discuss in a moment, resolve errors. This is purely a timing issue as to when notice of cancellation is effective. Once notice to cancel has been given, within 3 business days of receiving the request, the provider must refund the total amount of funds given by the sender, including fees, and to the extent not prohibited by law, taxes. This slide lays out the general timelines and requirements for the rule's error resolution process. Under the statute and the rule, the sender has 180 calendar days to report an error. As with cancellation, commentary to the rule explains that notice to an agent is deemed to be notice to the provider for purposes of lodging an error under the rule. As explained in the preamble to the February 2012 release by the Bureau, senders that have a problem or issue with particular transfers may contact the agent location that the sender used to send the transfer to resolve the problem or issue, rather than notifying the provider directly. A question has come up about how notice would operate in the non-agent context. For example, what happens if a bank customer provides notice of an error at a branch location? Bureau staff believes that the same concept applies in the non-agent context. That is, notice of an error at a branch location would be noticed to the provider. This is where a customer is most likely to go to report an error. Again, I'd like to note that an agent is not required to perform error resolution procedures, and the same would apply in non-agent context. The agent or frontline employee could direct the consumer to the right number or department for the actual resolution of the error, but the time to lodge an error tolls upon telling that agent or frontline employee about an error with the transaction. Once an error is lodged, a provider has 90 calendar days to investigate and make a determination. A provider may not charge fees for the investigation. Once the investigation is complete, the provider has 3 business days to report the results to the sender. Note that business day is defined in the rule. If an error occurred, the provider must correct the error within 1 business day or as soon as reasonably practical after receiving the sender's instructions. The sender's instruction depends on the type of error and the remedy available, but note that there's different procedures for errors that occur because of a mistake made by the sender. One question asked was whether the rule permits providers to offer immediate error correction without triggering the error resolution process. The commentary to the rule addresses this and states that the provider may correct an error without investigation in the amount or manner alleged by the sender or otherwise determined to be an error, but must comply with all other applicable requirements of the error resolution provisions, including providing notice that the error was resolved. There are 5 types of errors in the rule. Errors generally include the incorrect amount of currency paid by the sender, the incorrect amount of currency received, and late or non-delivery of remittance transfer. These 3 are the primary types of errors. There are also exceptions from the definition of error. With respect to the incorrect amount of currency received or the late or non-delivery of a remittance transfer, there is an exception in the rule if the failure resulted from extraordinary circumstances outside the provider's control that could not have been reasonably anticipated. The commentary explains that extraordinary circumstances includes war or civil unrest, natural disaster, garnishment or attachment of some of the funds after the transfer is sent, and government actions or restrictions that could not have been reasonably anticipated by the provider, such as the imposition of foreign currency controls or foreign taxes unknown at the time the receipt or combined disclosure is provided. I will address in a moment a new exception for situations in which the sender provided an incorrect account number or recipient institution identifier and certain conditions are met. With respect to late or non-delivery of a transfer, there is also an exception for delays due to Office of Foreign Asset Control or other fraud screens, as well as friendly fraud. A question we've received is whether this would include delays caused by fraud screening or BSA OFAC procedures by entities other than the provider. Bureau staff would read or similar laws or requirements to include delays caused by these procedures by entities other than the provider. As discussed in the preamble to the February 2012 rule, the Bureau understands delays to be infrequent, aka this does not include ordinary delays. Errors also do not include status inquiries, recipient requested changes, or changes in the amount or type of currency if the provider relied on information provided by the sender. As I noted a moment ago, as part of the recent changes to the remittance transfer rule, the Bureau created a new exception from the prior rule's error provisions for certain situations in which a sender provides an incorrect account number or recipient institution identifier and that mistake results in the transfer being deposited in the account of someone other than the designated recipient. For this exception to apply, a remittance transfer provider must satisfy a number of conditions. If any of the conditions are not satisfied, the exception does not apply. Note that the new exception is for mistakes regarding an account number or what the Bureau calls a recipient institution identifier. The rule explains in some detail what is meant by recipient institution identifier, but generally speaking, it refers to a routing number or SWIFT or BIC code that might be used to identify the foreign institution to which the transfer is being sent. In addition, this exception only applies for transfers to an account. Now let's discuss the 5 conditions for satisfying this exception. The first is that the provider demonstrated that the sender provided an incorrect account number or recipient institution identifier. The second condition requires that the provider implement reasonable verification measures to verify the accuracy of a recipient institution identifier. This condition does not apply if the error with the transfer involved an account number. It only applies for errors in connection with a recipient institution identifier. In addition, the commentary to the rule explains that what is meant by implementing reasonable verification measures. The third condition is that the provider gave appropriate notice to the sender that the transfer amount could be lost. The rule does not specify the form of such notice, but it must be provided clearly and conspicuously, and prior to when the sender makes payment for the remittance transfer. The fourth condition is that the funds are actually deposited into the wrong account, as opposed to being held in abeyance by some institution abroad, or not actually being deposited into the wrong account. The fifth condition is making reasonable efforts to retrieve the misdeposited funds. The rules does not provide specific instructions on what reasonable efforts should be used, but provides a general framework for how a provider should attempt to recover misdeposited funds. This slide discusses remedies for when an error occurs. The remedies generally available include refund or resending the transfer in an amount appropriate to correct the error. The resend generally has to be done at no cost to the consumer. If the error is a failure to make funds available, including late or non-delivery, then there is a separate remedy. Generally speaking, a refund of fees and taxes charged is imposed. Taxes need only be refunded to the extent allowed by law, and to the extent that they were collected from the sender at the time the sender authorized the transfer. The Bureau also recently made an adjustment to the remedy available when an error occurs because the sender provided incorrect or insufficient information. In such cases, the remittance transfer provider shall refund to the sender the amount of funds provided by the sender in connection with the remittance transfer that was not transmitted, within 3 business days of providing the error investigation report, except that the provider may agree to the sender's request, upon receiving the results of the investigation, to apply the funds towards a new remittance transfer. The provider may also deduct from the amount refunded or applied towards the new transfers any fees actually imposed or, to the extent not prohibited by law, taxes actually collected on the transfer as part of the first unsuccessful remittance transfer attempt. The provider may not, however, deduct its own fee. The statute also required the Bureau to implement liability rules for providers, including for providers that act through their agents. A provider under the rule is strictly liable for violations of the rule by its agent when the agent acts on behalf of the provider. Agency is generally defined by state law or state common law, so whether an entity is an agent of a provider is not something the Bureau can provide comment on. The next several slides discuss remittance transfers scheduled in advance. The rule has specific procedures for transfers that are scheduled in advance, whether the transfer is one-time or recurring, such as a recurring monthly transfer. In these circumstances, the remittance rule provides time requirements for disclosures for subsequent transfers, as well as for the refund cancellation period. For a one-time transfer scheduled before the date of transfer, or for the first in a series of pre-authorized remittance transfers, scheduled 5 or more business days before the date of transfer, estimates are permitted in the prepayment disclosure or receipt provided when the transfer is scheduled. An accurate receipt is required unless another statutory exception applies. For subsequent transfers, a prepayment disclosure is generally not required. However, an accurate receipt continues to be required, again unless a statutory exception to the accuracy requirement applies. Continuing to discuss remittance transfers scheduled in advance, there must be a disclosure of the transfer date as well as the transfer date of future scheduled transfers as part of that series. Thus, for one-time remittance transfers scheduled 3 or more business days in advance, and for the first in a series of pre-authorized remittance transfers, the transfer date must be disclosed on the initial receipt and all subsequent receipts. For subsequent pre-authorized remittance transfers, i.e. all transfers in the series after the first, The provider must also disclose the future date or dates of the subsequent transfers, cancellation rights, and the provider's contact information. The rule provides flexibility on how these subsequent dates are disclosed. The subsequent pre-authorized remittance transfers scheduled 4 fewer business days in advance must be disclosed on the initial receipt for the first transfer. Cancellation and refund policy for remittance transfers scheduled in advance. For any remittance transfer scheduled at least 3 business days in advance, the sender may cancel at least 3 business days before the scheduled date of the transfer. If the transfer is scheduled 1 or 2 business days in advance, then the standard 30-minute cancellation period applies. The remittance rule is effective October 28, 2013. As you may know, this is a delay from the previous effective date of February 7, 2013. The Bureau received a number of comments in response to its December 2012 proposal requesting a delay in the effective date in order to allow for compliance with the new rules requirements. The Bureau believes that this should afford entities sufficient time to make any necessary changes to forms and systems to capture the refinements made in May 2013. Now I'd like to spend a moment discussing a few of the resources that the Bureau has made available. You can find all of the resources available regarding the remittance rule on our website at the link on this slide. In addition to the countries list which I've already mentioned, we have also published a small business compliance guide which is available for download. Inside this guide, we've included a number of non-legal, practical implementation tips that may be useful in thinking about your institution's compliance issues. Importantly, we will continue to closely monitor the remittance market and will continue working with you to provide guidance and answer implementation questions. We appreciate all of the work that many listeners have already done towards compliance and your continued efforts to be compliant before October 28th. If you have any ongoing legal questions about the rule, please do not hesitate to contact us at the number or email address provided above. We also welcome your feedback on our countries list or small business compliance guide at either of these email addresses. Thank you again very much for your time and interest in this topic.